Hello everyone, I'm Peggy Lynch with the Richmond Association of Realtors, bringing you another COVID-19 Realtor Update. This video is being made on Wednesday, April 1st. I'm here with CVR MLS Legal Counsel Michael Lafayette, who will be answering some of the questions you have submitted concerning the practice of real estate during the COVID-19 outbreak. If you would like to submit a question for consideration in a future update, you may do so by visiting our website, rarealtors.com/COVID-19. Michael, let's start off with the Governor's Executive Orders 53 and 55. We have touched on this topic in previous updates, but can you give us a brief synopsis of how real estate services are affected thus far?
Yeah, so with Executive Order 53, which was put out by the Governor on March 23rd, it specifically stated that some businesses had to close, like restaurants and recreational facilities. But very importantly, it did allow for professional services to continue. That includes real estate agents, real estate practice, and also closing attorneys. So the practice of real estate could go on. And then just this week on Monday, March 30th, Executive Order 55 came out. And basically what that did was just restate Executive Order 53. So in other words, professional services as a real estate agent, buying and selling, assisting people to buy and sell their homes can continue in place. But there's one caveat with that, and that is what the governor had said back last week. We cannot have more than 10 people in a room, and we have to keep the 6 feet distance, the social distancing, okay? So it's really important to you as a real estate agent to understand that while you can continue to practice real estate, you have to keep in mind no more than 10 people, and then also keeping the 6 foot distance. So here's a couple steps you need to take. First of all, don't have an open house. That is collecting people. That is, and it's hard to control the distance. It could be easily overwhelming over 10, and you'd be violating the order. So don't have open houses. So instead, do virtual open houses, send out videos, photography, photographs, anything like that. Point them to any websites, information like that can provide to the prospective purchaser. So you're not shutting down the selling of a property. You're just making technology available, or making the property available through technology. So that is really, really important. If you're a buyer's agent, make sure your buyers look at the property either online by looking at video, looking at photographs, going to MLS listings. Make sure they're really interested in this property. Don't jump in your car, take them around to 20, 30 different places or homes or anything like that. That's really crazy because the governor said let's minimize contact. So we have to do our part, both as realtors and brokerage firms, to make sure we minimize contact. So make sure if you're going to show a house, that is someone who's really prospective of a purchaser, as a purchaser, of that property. So in other words, minimize taking them around, make sure they have viewed the property online before they go take a look to make sure they're a serious purchaser of that property.
Along those lines, some agents and firms are limiting access to listed properties to only those individuals who will be principals to a purchase offer, asking that children not be brought along on a showing appointment, or requiring pre-approval letters or proof of funds in order to view a listed property. Are any of these requirements problematic?
Those problems individually or those practices are not problematic unless they're not done uniformly. So let's just take them one at a time. So let's just say you're asking for a pre-qualification letter. That's fine. It is fine to ask for a pre-qualification letter that the buyer is pre-qualified, but make sure you ask that of all buyers. Don't pick and choose. If you pick and choose, that's where fair housing, a violation could come in, or at least be inferred that it's a violation or be accused of a violation. And we don't want that to happen. So again, if you're going to do a pre-qualification from a lender, make sure it's applicable to all buyers. Ask all buyers for that pre-qualification letter. As far as not having children come in with their parents to view the home, totally fine. That is not fair housing. That's not discrimination against children because they're not the purchasers of the property. You're not discriminating against selling the property to them. You're just trying to limit the number of visitors into the property.
We are hearing that some home inspectors and appraisers are requiring that they be alone in a listed home when providing their agreed-upon services. What advice do you have for agents when they encounter this precondition, and how should brokers advise their agents concerning unsupervised access to a listed property?
Make sure we all understand that allowing someone unaccompanied in the property is not permitted under the D4 regs without the consent of the owners, so your sellers. So you can't do that. and you have to advise your agents if you're a broker accordingly. And of course, if you are the agent that's on site and the appraiser or the inspector wants to go on the loan, you have to tell them you can't. And you have to explain that the law does not allow without the consent of the seller. Your seller may or may not give consent, but if they're going to give consent, my suggestion is to get that in writing or at least by email. If you can't get that, at least verbal, then make a note of it. But you need the consent of the seller. The only exception at this point is in the listing agreement, where if that has not been stricken, there is pre-printed language that says that the termite inspector may visit the property, may inspect the property, and you don't have to accompany the termite inspector. So the bottom line is the D4 regs are not set aside even during this pandemic, and you have to make sure that visitors to the property are accompanied unless you have the seller's consent.
Can you update us on the status of the courts right now when it comes to e-recordings and whether settlement agents are open and operating?
Yeah, so we have good news with respect to the courthouses. We're very fortunate in the Richmond metro area that the courthouses remain open for e-recordings. That is the electronic recording of deeds of trust and deeds and things like that for the transaction. All courthouses, as we speak today on April 1st, are open and operating with respect to e-recordings. They are not open and operated for the general public for purposes of trials and things like that, but they are for real estate business, which is e-recording. So far, so good with respect to that. With respect to title companies and closing attorneys, they also are open, and those who are able to do e-recordings can continue with the real estate closings. I mentioned this in a prior video, and I'll mention again, make sure that if you are referring to a settlement company or closing attorney for closing, or if you're involved in a transaction now, make sure whoever's doing that closing has the e-recording capability. It's not just as simple as submitting a document online. That closing attorney or title company has to have set up with a third-party vendor in order to do e-recordings. There's a bunch of steps that have to go through, so it's not just as simple as pressing a button and automatically filing at the courthouse. There's actually a pretty good number of steps that have to be taken, and you have to be pre-approved by the clerk. So I wanted to clarify that. So it's not just easy, press a button. The title companies, closing attorneys have to get pre-approved, and if they're not pre-approved now, it's difficult to get approved because of the backlog. So just make sure that they are approved so that way your closing is not delayed.
We're also hearing that some buyers are requesting early possession as an alternative to the delayed closing related to COVID-19 concerns. What should agents keep in mind when advising their clients about this?
Early possession may be a very good remedy for a delayed closing. And there's no difference now with the pandemic versus delayed closings, that happened before COVID-19 was, among us. Okay, so the common sense things to remember is this: why is the closing being delayed? Is it being delayed because the purchaser has not completed its loan application or provided information to the lender? That may be a red flag, because that means it's the purchaser who hasn't done what they need to do. And do you really have strong confidence that the purchaser is going to continue with the transaction if they haven't done what they're supposed to do? As opposed to a transaction where the purchaser has done everything they need to do and the lender's just backed up. Maybe there's some type of pre-approval, certainly the pre-qualification's through, but even with that, the lender can give you some assurances that, listen, the purchaser's done everything they can, we're just backed up, we can't process. There's also a refinance boom going on right now. Lenders are trying to give preference to, purchase transactions, but nevertheless, they're backed up. Some of the lender employees are working from home. So anyway, find out why it's not closing, particularly if it's a lender issue. And if it sounds like it's a legitimate lender issue, then you may want to consider, if you're the listing agent, discussing it with your seller. Say, hey, listen, here's a good situation where we could probably do early possession. It allows the purchaser in there. It keeps the transaction going. It may delay closing, but it does allow the transaction to move forward, particularly if the seller has already moved out. And then lastly with that is there's nothing wrong with the early possession agreement. And let me back up for 1 second. Realize we do have an early possession agreement form in the CVR MLS form file, and I strongly urge you to use that form because it's very comprehensive. That particular form provides for a security deposit. With that security deposit, that is extra protection to the seller. So that's above and beyond the deposit that's in the purchase agreement. So I would encourage, if the early possession agreement is going to be executed, that you should really think seriously if you're the listing agent recommending an additional security deposit to protect the seller or owner of the property in the event something goes wrong with that possession. So just still the same common sense provisions or thoughts that you would give any early possession. That's what's in place today.
We have received a few questions related to whether or not commercial real estate services are also considered essential under the governor's emergency order. Could you speak to this?
Sure. So let's make sure we clarify, and we have all thrown around, including myself, whether or not real estate services are essential, whether closing services are essential, things like that. The real way to look at this is what is allowed to operate and who's allowed to be open and operating, who's not. Clearly, the essential operators are like the hospitals and things, but then other businesses, which are goods and services providers, unless they've been closed by the governor, then they're just allowed to operate. And so real estate, whether residential or commercial, is being allowed to operate. These are just goods and services, or in our case, services that can continue to operate in the Commonwealth and are not restricted. So whether it's residential or commercial, you can certainly continue to operate your business. As I mentioned a few minutes ago in this video, commercial realtors will fall in the same position as residential. You got to have the 6-foot distance. You cannot have meetings of more than 10 people. And I realize sometimes in commercial you kind of get a group together. Don't do it. Do it by phone, do it by video conference, do it otherwise, but don't hold a group meeting in a conference room. That's just going to add to troubles. You just can't do it. But you can do it virtually. You can do it by phone, otherwise, and you certainly can show the properties just like a residential agent can.
Some of our members practice property management or own rental properties. Are there any special considerations for showing rental properties or removing tenants?
Yeah, so let's break it down, showing properties. To me, it's time for listing agents, those who are representing landlords and showing properties, to be as creative as those who sell real estate. And that is use of virtual tours, photographs, and things like that. That's what you should be doing. If you have properties available for lease, instead of bringing that tenant in right away, make sure the tenant has viewed the property virtually or photographs, other things, and make sure they're really a legitimate tenant. Just as I mentioned a few minutes ago with respect to the sales transaction, it's the same thing for leasing. Don't bring a tenant around looking at all the various different properties. Make sure you narrow it down online first and make sure they're really an interested or prospective tenant for that particular space. So that way you're limiting the number of available or units that you have to show. So that's what's important. So use technology to help you and make sure it's narrowed down when you take the tenant to the property to view it. So that's what I would say with respect to showing properties. And everything else still applies, as I mentioned during the residential sales piece, which is, keep the 6-foot distance, no groups. All that still applies even with leasing. Now, as far as evictions, that is a really big problem right now. So if you're in the property management sphere of things and you represent landlords, it's a real problem. It's twofold. One, there's moratorium on evictions, and two, the courts are closed. There is no court dates. You can't get a court date right now for an eviction. So what I would suggest you do is work with that landlord and make sure the landlord is talking with their attorney. There are some options, whether it's deferred rent payments, rent paid later, whether it is rent that is abated. Abated means not paid at all, so it's forgiven. Workouts, different things that you can use with that particular tenant to help out. Bottom line is landlords are all going to be hurt by this, whether rent is paid or rent is delayed, and you need to really strongly advise your landlords to work with tenants. It's not going to get any better soon. It's only probably going to get worse. And with the courthouses being closed for new cases to be filed and cases to be heard, it really is going to put a lot of stress back on the landlord and the landlord's attorney to work things out with the tenant. And that's what I strongly recommend, that the landlord and their attorney work things out, because it's going to be months before they can see a judge and take care of things through the courthouse.
Thank you, Michael. As you know, COVID-19 information is changing rapidly. The information in this discussion is current as of the date of this recording. You can find the most up-to-date information and resources for realtors on our website, rarealtors.com/COVID-19. RAR and CVR MLS remain committed to providing you with the resources and services you need to conduct your businesses in a virtual environment. Please do not hesitate to reach out to us if we can be of assistance. Be well, be safe.